One important distinction to make is that the Web Content Accessibility Guidelines, or WCAG, are not the law, and they never are. They may be adopted or incorporated into the law, but they are not the law itself. And specifically, when it comes to the Americans with Disabilities Act, the compliance standard is meaningful access. It's not the Web Content Accessibility Guidelines. The way to look at this is the Web Content Accessibility Guidelines are a helpful reference when it comes to having meaningful access. So that what that means is the Web Content Accessibility Guidelines tell us things that we need to do, considerations that we need to make to ensure that our digital asset is at a basic level accessible. But just because we are not in perfect conformance with WCAG doesn't mean that we are in violation of the ADA. So they are not the same. But importantly, plaintiffs' law firms like the technical, the rigorous technical standards because they pave the way for so many instances in which it can be said that a website, for example, is not ADA compliant. Well, even if a website isn't perfectly conformant with even a single success criterion under conformance level A, which is the basic which is a conformance level that includes the most basic and fundamental accessibility considerations. Even if a website isn't perfectly conformant with a very important success criterion, it doesn't mean it wouldn't be considered ADA compliant. But the problem is going through and technically making this argument, because we can look at a website, we can evaluate it, and we can determine whether it's still practically accessible or whether something is more of a minor accessibility issue versus one that's creating an outright barrier to access. We can look at that and we can determine, okay, the code is not structured correctly, but nevertheless, access is available. Even if someone has a disability, they are still able to access without significant degradation in experience. It might be like a minor inconvenience. It might be something that's suboptimal. It's not perfect, but it's still accessible. And plaintiffs' lawyers, they don't understand this fully, and they're not in the business of making these distinctions. They're not going to parse through whether something is technically accessible, technically an issue versus actually practically accessible anyway. That's not what they're going to do. But it is important to know and to be aware of the fact that right now the legal standard is meaningful access under the ADA. It is not perfect WCAG conformance. Now, best practice is WCAG conformance because you don't want to leave anything to chance, right? It's best not to have an image with no alt attribute, even if you can argue, okay, nobody's been denied access here. It's best not to have that even come up because you want to preempt any type of litigation. You don't want to be in a situation where you're going back and forth with a plaintiff's law firm and trying to convince them of why their claims are wrong, because plaintiff's law firms, they don't want to listen to that. They'll just say, okay, we'll file a complaint. Most will file a complaint in court and let it work out from there, and typically it ends up in settlement because it's simply not worth it to go back and forth and argue on these things. Sometimes though, many times, there are actual issues that create a significant degradation in experience and can outright prevent access, and that's a gray area in and of itself. So at what point is meaningful access denied, right? If I have to spend 20 minutes on the website to access information or complete a task versus the 2 minutes it would have been if you would have made accessibility considerations. Has meaningful access been denied? And that is a question that would have to be worked through. But the point of this video is that merely not meeting certain WCAG success criteria does not mean that you have violated the law. Moreover, even if the web content accessibility guidelines are incorporated into the law, so let's look at section 508, because in section 508, WCAG 2.0 conformance level AA is incorporated into the law. Even if it is, what we'll commonly see come up is the term substantial compliance. And what that means is there may be a minor issue. It may not, you might have you won't have perfect conformance, but you'll have a very accessible digital asset. And in that case, it will be considered substantial. But then again, we get into a gray area and here's why accessibility and the law is so difficult, is because there are gray areas. There are, these standards are very technical, and at times it's subjective whether or not you even meet the standards. But even if you don't, it doesn't necessarily mean that access has been denied. So I'll give you an example. One success criterion and a success criterion is basically a requirement under these technical standards. One of them is that there be a 4.5 to 1 color contrast ratio with text in the background. So let's say that your color contrast ratio is 4.49, which would be it's virtually the same. It's so close to the same color contrast ratio. But if that was the case, would that mean that you were in violation in the law and denied someone access on the basis of disability? That's the type of question that we have to look to, and we have to understand what is actually in play here. And so there's significant give and take, and what we're really looking for are ways in which someone's experience has been significantly affected in a negative way, where there's been a detrimental experience, a degradation in experience, or an outright barrier to access. So the web content accessibility guidelines are a very helpful reference. At times they may be incorporated into the law. I think we will see more incorporation going forward, but they are not the law themselves. And I think we will see continually, if anybody looks for a strict adherence to the web content accessibility guidelines, we will see exceptions carved out to where we will see words like substantial conformance and substantial compliance come up. But importantly, the best practice is to be in full conformance. Strive for full conformance with WCAG 2.1 conformance level AA. But if you are in litigation, understand that the web content accessibility guidelines are very technical standards. They are open at times they are subjective, and that there is the legal standard under the ADA right now is meaningful access, and the web content accessibility guidelines to date have not been incorporated into the law.